Hello friends and welcome back to my channel Advocate Pramod Bhardwaj Speaks. I'm Advocate Pramod Kumar Bhardwaj and today we'll be discussing an important topic that has been the subject of much debate in the family law in the UK, no-fault divorce. In this video, we'll explore the evolution of the law surrounding no-fault divorce, why it was needed, its advantages and disadvantages, the procedures for filing it, and how it affects different groups of people including natural-born UK citizens, people with indefinite leave to remain, specifically non-resident Indians. So let's dive in. For many years, divorce law in the UK required that one party must prove the other was at fault in order to get a divorce. The grounds for divorce were based on adultery, unreasonable behavior, desertion, or living apart for a specified period of time. This system often created a very adversarial environment, with one party being blamed for the breakdown of the marriage. The process was stressful, costly, and sometimes harmful to the emotional well-being of the spouses, especially when children were involved. Recognizing these issues, the UK government introduced reforms aimed at making the divorce process less confrontational and more straightforward. These reforms came to fruition with the Divorce Dissolution and Separation Act 2020, which came into effect on April 6, 2022. This act finally brought about the long-awaited no-fault divorce system, allowing couples to divorce without having to prove one party is at fault. The system aims to reduce conflict, make the divorce process quicker and simpler, and allow couples to separate without the emotional strain that proving fault could bring. The need for a no-fault divorce system arose from the difficulties many couples faced under the previous law. The requirement to prove fault often resulted in more conflict between spouses, especially when children were involved. Instead of focusing on the decision to divorce, the process became about assigning blame, which only aggravated the situation. Additionally, the old system was cumbersome and costly, with couples having to provide evidence of wrongdoing, which often meant engaging in lengthy legal battles. The new system helps address these problems by focusing solely on the irretrievable breakdown of the marriage rather than assigning blame. There are numerous advantages to this no-fault system. Firstly, it significantly reduces conflict between spouses, which is particularly beneficial when there are children involved. By removing the need to prove fault, couples can focus on making amicable decisions about how to move forward with their separation. Secondly, the process is much quicker and simpler. Without the need for one party to prove fault, the entire process becomes more straightforward, meaning that divorce proceedings can be completed in a much shorter period of time. Another advantage is that it is cost effective. With fewer legal disputes and no need for evidence gathering, the overall cost for divorce is significantly reduced. Lastly, the emotional toll of divorce is lowered. The previous system often forced couples to rehash painful experiences in court, whereas the no-fault system allows both parties to move on without unnecessarily emotional distress. However, like any legal reform, there are also disadvantages to the new system. Some critics argue that the ease of divorce could weaken the commitment to marriage and make it too simple for people to dissolve their relationships. While the aim of the law is not to encourage divorce, some believe that it could inadvertently encourage people to take the option of divorce without giving sufficient thought to reconciliation. Additionally, while the system reduces conflict, it might also make it easier for one party to manipulate the situation, especially in cases involving domestic abuse or other serious issues, as the focus shifts away from the causes of marital breakdown. Lastly, there may be financial implications for some individuals, particularly if the division of assets or child custody arrangements are complicated. Now let's talk about who can file for a no-fault divorce. The law in the UK is clear. Either spouse can apply for a no-fault divorce provided they meet the basic requirements. There is no need for one party to provide evidence of wrongdoing or prove that the other is at fault. Instead, the only requirement is that the marriage has broken down irretrievably. This can be confirmed through a simple statement, and it is not necessary to go into the details of why the marriage ended. The procedure for filing a no fault divorce is relatively simple. You can apply online, which makes the process quicker and more efficient. The first step is to submit a statement confirming that marriage has irretrievably broken down. After that, there is a mandatory 20-week reflection period during which both parties can reconsider their decision. After this, decree nisi is issued and a final decree absolute, is granted after another 6-week period, making the divorce final. One of the key elements of this system is that the divorce is no longer a battle over fault. Both parties can agree that their relationship has come to an end without the need for a drawn out legal process. This approach has been praised for making divorce less stressful and more dignified for everyone involved. Now let's take a closer look at how this law applies to our different groups of people. For natural born UK citizens, the process is straightforward. They are eligible to file for a no fault divorce, and as long as the marriage has irretrievably broken down, they can proceed with the application. For immigrants and individuals with indefinite leave to remain, the situation is slightly different. To file for a no fault divorce in the UK, either of the spouses must meet the requirement of being habitually resident in the UK or domiciled there. If one spouse is an immigrant or holds ILR but is not residing in the UK, they may not be able to file for divorce under UK law. However, if the couple has strong ties to the UK and one of them is residing in the country, they can apply for divorce in the UK courts. When it comes to non-resident Indians, the situation becomes more complex. An NRI can apply for a no-fault divorce under UK law, but they must meet certain criteria. For an NRI to file for a divorce in the UK, they must be domiciled or habitually resident in the UK. This means that even if an NRI is not a permanent resident, but they are living in the UK on a long-term basis, for example, for work or study, they may be eligible to apply for a no-fault divorce. However, if neither spouse is residing in the UK courts may not have jurisdiction over the divorce, and the couple may need to consider filing in their country of residence. If an NRI is already divorced in India and wishes to have the divorce recognized in the UK, the recognition process will depend on whether the divorce was conducted in accordance with the law and whether the UK courts accept foreign judgments under the Foreign Judgments Act. In conclusion, the introduction of no-fault divorce in the UK has been a positive step towards simplifying the divorce process, reducing conflict, and focusing on the irretrievable breakdown of marriages. Whether you are a natural-born UK citizen, an immigrant, someone with ILR, or an NRI, understanding how this law applies to your unique situation is important to navigate the legal landscape effectively. If you found this video helpful, don't forget to like, share, and subscribe to the channel for more legal insights. You can contact us through WhatsApp or email. The details are provided in the description below. Thank you for watching, and I'll see you in the next video.